May I please, your lordships?
Yes,
My lord, I beg to mention item number 5.
5.
The petitioner have filed a additional affidavit. And I would like to file a short reply to the additional affidavit. So 3 weeks time may be given, lordship.
Yes, Mr. Yes, Mr. A. Jimomi, learned counsel for the petitioners heard, and Mr. C.T. Jamil, learned senior counsel for the respondent number 5. Also heard, Mr. Who is the for the okay. Mr. Jamil, learned senior counsel preparing for the respondent number 5, has submitted that he has received a copy of the additional affidavit filed on behalf of the petitioners recently and has sought 3 weeks time to file a reply to the said affidavit. Also, the prayer made by Mr. Jamir is stands allowed, release the case before the division is after 3 weeks.
My lord, I also beg to mention item 15 and 16.
15,
And
16.
16. So your worships, on the last occasion, records we called for.
Okay, let us see.
So records have not been. Records
15,
have not
16.
arrived.
Appeal preferred by NI.
Yes, ma'am.
My lord,
Who is the counsel for NI?
I'm appealing for.
Mr. NN Mishra.
Devashish Tandon.
NN Mishra.
No, sir. My lord, Devashish Tandon.
D.
Devashish Tandon.
Tendon. Okay, you're a
Because the
public
previous
prosecutor.
counsel actually is being transferred to UP right now. So
You're the
now
public
I-
prosecutor for NI.
Yes.
Okay, learned public prosecutor. For the appellant NI and Mr. A. Jimomi, learned counsel for the respondent. Full stop. By which order scan copies were called for? As per office note dated 13/11/2013, 23, comma, the scan copies of the case records from the Court of Learned Special Judge NI Dimapur have not yet been received. Full stop. Office to issue a reminder First up, release the case after 3 weeks.
On the 13th of December.
13th of
13th.
December works.
Yes.
Release
That's a division bench.
Division bench.
Yes.
Release the case on 13/12/2000 cases. Release the appeals.
Much obliged.
Same order. Separately. Same order separately.
Please, Lordships.
Yes.
I beg to mention item number 3.
3.
Kindly allow me 1 week to file affidavit money.
3. You are for the state,
Said yes, ma'am.
Mr. Thiba Form,
Yes, my lord.
learned senior government advocate,
No government advocate, ma'am.
learned government advocate, appearing for the state respondents, has prayed for a week's time to file counter affidavit on behalf of the state respondents. Mr. Tak, you are for
Lordship, I'm W. Mahro on behalf of Takakichu.
Mr.
W. Mahro.
W. Learned Counsel, representing Mr. Takakichu, Learned Counsel for the petitioner, is in attendance. First, release the case, the prayer made by so Thiba Form is allowed, release the case after a week.
My lord, again, I beg to mention item number 26 on behalf of Vizomome, my lord. Kindly list the matter after 2 weeks, ma'am.
26.
Yes, my lord.
Mr. Thiba Form, Learned Counsel, representing Mr.
Vizomome.
V. Jimomi,
Yes, ma'am.
Learned Public Prosecutor,
Yes, my lord.
Nagaland, has sought listing of the appeal after 2 weeks.
My lord,
Mr.
to show along, my lordship.
Learned Counsel for the appellant is present and has no objection for that.
But in the meantime, LCR may be called.
Yeah, huh?
LCR.
LCA is not called for.
Yes, lordship.
Let us see. Let the LCR of case records. Case records of ZR case number 114/2019 be requisitioned from the Court of Learned Sessions Judge, Kohima.
Much obliged.
May I please, Lordship? I'd like to mention for item number 21 and 22.
21.
21 and 22. Lordship, these two are analogous matters. Lordship, I'm for the petitioner in item number 21.
21.
And my learned friend is appearing in item number 22. So, this matter will be taken up after 3 weeks.
You are appearing in 21.
21, Lordship.
Mr. Lima Wapang, Learned Counsel for the petition in Civil Revision number 5/2020. And who is appearing for the petition in 22? Mr. Learned Counsel for the petitioner in Civil Revision number 6/2021, and Mr. Ain Chen,
I am for state, your lordship.
Learned State Counsel for the response.
Lordship, I am for the sole respondent in item 22.
Okay, Mr.
Respondent number 2. Respondent number 2, Lordship.
Kekring Guli,
Lordship.
Learned Counsel for the respondent number 2 in Civil Revision 6/2021 are present. SR in respect of respondent number 4 and 5 in Civil Revision 5/2020
Lordship,
are awaited.
you're not represented.
Let us wait 3 weeks, you want 3 weeks?
3 weeks, Lordship.
As per office note dated 11/9/2023, comma service reports in respect of the respondent number 4 and the respondent number 5 in Civil Revision number stroke 2020 are awaited. First of, place the case after 3 weeks for service reports in respect of the respondent number 4 and the respondent number 5 in civil division number 5 2020.
Please, Your Lordships, I beg to mention hearing item number 18.
18, yes.
18, Your Lordship. I pray that the matter may become after 3 weeks, Your Lordship.
Yes, your appeal.
Yes, Your Lordship.
Okay. V. Shukri, learned additional advocate general for the appellant is present. Mr.
Subhamati.
On the prayer of Mr. Subhamati Waling, learned counsel for the sole respondent. Come on, let the case be listed after 3 weeks.
Obliged, Lordship.
May I please, your Lordship? My Lord, I pick the mission item number 11 on behalf of my friends, Gauhati. Let this matter become up after 2 weeks.
Okay. Who is for the petitioner? PL petitioners? You have informed? You have informed?
No, my Lord.
Let us see.
Please, Your Lordship.
Amended cost title.
Lordship, I've taken necessary steps.
Amended cost title means?
Lordship, for respondent number 5, it was supposed to be director. Authority has to be director, but
I there or what? Why?
Lordship, for respondent number 5, as per the last order, I was directed to ascertain the necessary authority to represent respondent number 5. Therefore, I've taken necessary steps and
You have taken
filed it.
steps.
Yes, Lordship.
It is not reflected
Lordship, I filed it yesterday.
yesterday.
Yes,
Upon respondent number 5.
yes, Lordship.
Okay, Mr.
K.R. Khan, Lordship.
Learned counsel for the petition has submitted that he has taken steps for service of notice upon the respondent number 5 recently. Post of Mr.
Lordship, that is for correction of course title,
So
Lordship.
then notice has to go.
Yes, Lordship. So, Lordship, may kindly allow me
right
to
now.
serve the notice to registered ID.
Mr. So-and-so. Let the petitioner side has filed amended cost title. Post of. Heard Mr. So-and-so, learned counsel for the petitioner and Mr.
On behalf of Gauhati, Zekengoli, my Lord. I am Zekengoli.
And
I am
the
behalf of-
newly learned counsel preparing for Mr. Yangarwati,
Yes, my Lord.
learned central government council. Also, then amended cost title petitioner side. The petitioner shall take steps for service of notice upon the respondent number 5 by registered 5 as well as 6.
Respondent number 5, Lordship.
No, you have made 6 respondents, right?
Yes, Lordship. Others have received, however, this respondent number 5, the notice returned unserved because
Shall
it
take
was not
steps for
addressed to the
service of
right
notice
authority.
upon the respondent number 5. Full stop. And who is respondent number 6?
Respondent number 6 is
Let us
Union,
see.
Lordship.
Okay. Within 2 working days from today, by registered post with AD. Raise the case after 3 weeks.
Obliged, Lordship.
Milord, I'm coming all the way from Kolkata. I'd like to file, Milord, an appeal against a single judge's order.
You file.
Milord, kindly, Milord, fix the matter in the second lab at 2. For I'll serve the petitions.
No, it is yet to be filed.
Yes,
After
it's,
filing, make
in the
the
process.
prayer.
Millard, already my junior has gone to file it, Millard.
Okay, if it is listed, if it is registered, it will be taken up.
Yes, Millard.
May I please, Your Lordship? Lordship, I beg to mention item number 19. Item number 19 on behalf of V. Devnath.
Okay, yesterday some mention memo was circulated, right?
Yes, Your Lordship.
MS,
So, Yekula,
learned counsel appearing for Mr. B. Devnath. Learned counsel for the appellant has made a prayer for adjournment on the ground that Mr. Devnath, Common Learned Arguing Counsel, is out of station due to medical emergency in the family. Post up. A mention memo to that effect has also been circulated on 15/11/2023. Post up. Mr. Who is for Oseko Pote,
Lordship.
Learned counsel for the respond number 1 to 11 has, who is in attendance, has no objection to the said prayer. Post up. By what time?
it's after 2 weeks, Your Lordship.
Okay, as prayed for, raise the case after 2 weeks.
Next, Lordship. Lordship, I beg to mention item 17.
17,
Lordship, on behalf of Mr. Benang Wapang, the counsel for the respondent number 5, CBI. 17, Lordship.
17,
Lordship,
on behalf of,
Mr. Benang Wapang,
yes,
the counsel for the CBI.
CBI.
Lordship. 2 weeks, Lordship. 2 weeks.
Lordship, I have a objection. Lordship, CBI also has filed their counter affidavit, in which they say that they have nothing to do with this case. And in fact, CBI has no involvement in this case. Now, about more than a month back, the appellant stated before this court that they have, there is a proposal to withdraw the case, which is also on the board. Now, even after the clear date, nothing has come forward. They are playing Your Lordship. And therefore, if they cannot withdraw, then let it be heard today itself.
Lordship, if I remember correctly, on the last occasion, that is 27th September 2023, I made a submission before the Honorable Court that I might consider for withdrawal of the case because there was some development. And in fact, there is a subsequent development. On 18th of October 2023, the Honorable Minister, Roads and Bridges, has called a meeting of the contractor and also the landowners who are the petitioners here. In view of non-execution of the work for more than a year, the minister has called for a meeting to find a solution. And they have mutually agreed to settle the dispute amicably. And in the meantime, the department has been directed to inspect the site at an early date so that necessary decision can be taken by the department. That is the subsequent development. I have a copy of that settlement also, which was called by the Minister of the Roads and Bridges, and contractor and the landowners have also agreed.
Mine is have been prepared.
Yes,
Your Lordship, as far as that is concerned.
I am furnishing a
we
copy
have
of
not-
the
We
Lordship.
have not received any instruction from my party. On the contrary, my party informed us, told us that the South Division has called him and offered him 40 lakhs so that the work can be done by some other person. That is what my party informed me.
so that effect I
And
have no
about
instructions.
meeting, we have not been informed of anything. So that is not, it cannot be true. Inspection may be there, because there is circulated in the local papers also.
Something is undertaken out of the court in the presence of the minister to sort out the issue, it appears.
So maybe.
His
because
signature
of
is
that-
there. His
because of
signature
that,
is available.
Your Worship,
His signature is available in this document.
yes, maybe. if that is so, then because
You
of
represent
that,
the contractor
my party
Lordship,
must. have
and
been
you
responsible
represent
for
whom?
2 lakhs.
You represent whom?
Your Lordship,
He is the
I'm
contractor.
the contractor, the respondent.
Okay.
So the South Division has offered me 40 lakhs.
The
So
contractor, he
the
was
first can be
present.
carried out by some other person.
The contractor was present.
But that was, we have not been informed of that. And maybe in that meeting, it must have been offered.
What is the
40
name of the
lakhs.
contractor?
Your Lordship,
What is the name of the contractor?
Root Hall. Z Root Hall.
Ahi Kechi.
No, he is among the landowners. He is one of the contractors. He is one of the petitioners. Then other two contractors.
Ritse, Anisa Ritse. Anisa Ritse, one contractor is present.
I'm not the one. I'm Z Root Hall. It's a firm.
But something has, some parley was held. Have you, in the meantime, received any instruction? No.
No, we have not received any information.
Better you take instruction in this
What we
matter.
have been told is that they were offered 40 lakhs to withdraw from the war so that they can be given to somebody. That's what we are informed. That's why they are playing. The landowners are playing.
What is the subject?
Lordship,
What is the subject matter of the petition?
It is with
Construction
regard to
of
the
roads.
construction of a road which goes through my village.
now on reaching the boundary of the appellant's village, we have been stopped from proceeding with the work. And then the monsoon set in. And despite the fact that the court has allowed us to
Okay,
carry out the work.
let the case be called up, we'll see.
Your Lordship,
Let the case be called up.
Your
When it
Lordship.
start, we'll see.
yes.
Keep this in 17.
This Lordship, I beg to mention item number 7. I may be allowed 2 weeks to file affidavit in reply. 789.
Okay, Mr.
W. Marshall, Lordship.
W. Marhu, Learned Counsel for the petitioners, has prayed for and is granted
2 weeks time, Lordship.
3 weeks time to file reply affidavit to the affidavit in opposition filed on behalf of the state respondents.
2, 4, and 5, Lordship.
Okay, 2,
Respondent 2, 4,
4
and
and 5. Okay. Mr.
I, Jamir.
I. Jamir, Learned Counsel for the respondent number 2, 4 and 5.
Lordship.
Is present and has no objection to proceed. This 7 is tagged with 8 and 9.
Lordship, yes, sir. No, goes matter.
You are a petitioner there.
Yes, Lordship.
Okay. In which case you want to file affidavit?
In item number 7.
Okay. Mr. Marhu is also the counsel, learned counsel for the petitioners in item number 8, WPC number so and so and so and so. List the case without prayer made by Marhu is allowed. Release the cases after 3 weeks.
Lordship, I also beg to mention item number 4. Lordship, here, this matter will be listed after 3 weeks, Lordship.
Okay, Mr. Y. W. Marhu,
Lordship, here I'm
learned
for
counsel
respondent.
appearing for Mr. Jade and
No,
Anguli.
Lordship, here I'm for the respondent, Lordship.
Okay, appearing for the respondent
Lordship,
has prayed for and is granted. How much time?
3 weeks time, Lordship.
3 weeks time to file counter affidavit.
No, Lordship, for admission hearing.
Okay, has sought for listing of the case after 3 weeks for admission hearing. And who is for the union? Mr. Jade and Anguli,
Yes, my lord.
Learned Central Government Council for the appellant. Has no objection to the seat fair. release the case after 3 weeks.
Much.
May I please, your lordships? Lordship, I beg to mention our orders, item number 13 and 14. Lordships, as per the office date, note dated 13/11/2023, service upon the sole respondent numbers 7 is awaited, lordship.
Okay, Mr.
I, Jamir,
I, Jamil, learned counsel for the petition.
appellant. Applicant.
Okay.
And,
Applicant.
lordship.
Applicant is present.
And lordship,
As per office note dated 13/11/2020. Of respondent number 7 is awaited, full stop. At least the case after 2 weeks.
lordship, I have a prayer that, I may be allowed to take, fresh steps upon the sole private respondent number 7 by way of the steel, lordship.
Okay. Await in respect of the await service report in respect of service of notice of under respondent number 7. Post of Mr. Maru.
I, Jamir, lordship.
Okay, I, Jamil, learned counsel for the appellant has submitted that the petition appellant may also be allowed to take steps for service of notice upon the respondent number 7 by way of the stay. The prayer for service of notice upon the respondent number 7 by way of the stay is allowed. The appellant shall take steps for service of notice upon the respondent number 7 by way of the stay, which is to be routed to the registry. Post of after effecting service of notice upon the respondent number 7 by way of the stay, the appellant shall file a compliance affidavit to that effect.
Obliged, lordship.
Lordship, I beg to mention, item number 12, the orders.
Orders,
Yes, yes.
yes.
Lordship, we have taken the step, upon respondent number 11 and 12. And to that effect, we have, filed our affidavit on 16/12/2022. So Lordship, the notice is not completed, so I pray that the matter may be listed for hearing on 13th of December.
Okay, let it come. You are here. You have urgency.
Lordship, I have.
For motion, item number 1.
Please, your lordships.
Yes.
This morning we have been served with a copy of the appeal memo along with the IA. In fact, this case has been filed some time back, but due to
Delay.
non-availability of bench, it could not be taken up. And I received instruction to represent the respondents. So,
All the respondents.
yes, so in respect of the IA, I would like to file my objection.
Okay.
For 3 weeks time.
Okay. MS V. Shukri, learned additional advocate general for the appellants. Art. And Mr. I. Iralu.
R.
Iralu, learned as senior counsel. I heard. Mr. R. Iralu, learned as senior counsel, assisted by Mr. has submitted that he has entered appearance on behalf of all the opposite parties.
Yes.
In the IA preferred by the appellants seeking condonation of delay. First of all, he has submitted that the opposite parties would file an objection to the interlocutory application. First of all, he has thus sought for 3 weeks time to file such objection. The prayer is allowed to release the I and the read appeal after 3 weeks.
For motion, item number 27.
May it please your lordships.
Yes.
Lordship, the petitioner herein is seeking for the revocation of the detention order dated 26/07/2023.
What is
By-
the FIR?
by this- Yes.
What is the FIR? I have the honor to
A
report.
copy of the FIR is
5-7.
at Annexure A.
Information was received from reliable source of illegal transportation of ammunition from Flag District. Accordingly, MVCP was conducted in PS jurisdiction and prohibited and ammunition were protected and seized from the possession of EBC Talim for Chilean of the suspect traveling in a taxi vehicle.
My lord, in this present case, based on the statement of this person who was arrested, during interrogation, he revealed the name of the detainee, and thereafter the detainee was arrested. And based on the proposal of the Superintendent of Police Kohima, the district magistrate passed the impugned
Nancy.
detention order. The
Where
petitioner
is the
herein is the
detention
wife-
order?
Yes, my lord.
Detention order?
The detention order is at page number 15, my lord. Annexure C. He has been detained under section 3 sub clause 2 of the National Security Act, my lord.
Abhinikha.
Yes, my lord. Abhinika is the detainee. And the petitioner herein is the wife of the detainee, my lord. So, my lord, here the petitioner begs to state that the detainee has been illegally detained on the grounds that the detainee was never produced before the advisory board within the mandatory period of 3 weeks. The detention order was passed on 26/07/2023. However, the detainee was produced only on 26/08/2023, my lord. Therefore, there is gross violation of section 10 of the National Security Act, my lord.
Yes, we will be accepting notice.
My lord, I'll be appearing for respondent number 1, 3, 4, and 5.
What is the approval order?
The approval order is at page number 23, my lord, Annexure E.
Heard, Mr.
Yes, of my lord.
A. Sophie. Learned counsel for the petitioner. Mr. Chivafong. Learned government advocate. Nagaland for the respondent number 1, 3, 4, and 5, and Mr. Anguli. Learned central government council for the respondent number 2, full stop. Challenging the detention order dated 26/7/2023 passed under section 3 within bracket 3 of the National Security Act 1980. This is number 1, Roman number 1, Roman 2. Approval order dated 7/8/2023. Passed under section 3 within bracket 2 of the NSA Act. And order dated 14/8/2023. 14/8 or what? Okay. Confirmation order dated 24/10/2023. Passed under section 12 within bracket 1 of the NSA Act in respect of the detainee named Abi Nekha. The present writ petition has been preferred. Full stop. The prime contention advanced on behalf of the petitioner inter alia is that the detainee was taken into custody on 5/7/2023. And a detention order was passed on 26/7/2023. But the detainee was produced before the advisory board only on 26/8/2023, that is, after expiry of the mandatory period. Well, right? Issue notice when the division will sit again after 3 weeks. Issue notice returnable in 3 weeks. As so and so has appeared and accepted notice on behalf of the respondent of so and so respectively. No formal notice need to be issued. Learned counsel for the petitioner shall furnish requisite number of extra copies of the writ petition along with annexure to so and so by tomorrow. The respondents shall invariably file their response on or before the next date of listening.
Much all right.
Yes.
For admission, item number 2.
Please, your lordships. Your lordships, the petitioners are Hindi graduates. They are challenging the Rule 7B, Clause 4 and 5 of the Nagaland School Education Service Rules 2017, lordship. According to the service rules, the rules have given preference to the students who have taken up Hindi as an elective subject. And the full-time Hindi students, they're left out, lordship. On top of that, my lords will also kindly appreciate this fact that those who have B.Ed has got nothing to do with Hindi studies, lordship. The B.Ed equivalent in Hindi is Parangat. So those who study BA with Hindi as elective subject and has taken up B.Ed, they are given preference, lordship. So that is directly in violation of Article 14 and 16 of the Constitutions, my lord. And I have.
Who are the petitioners?
The petitioners are Hindi graduates, lordship.
Hindi graduates?
Radna. Radna is equivalent to BA or BSc.
University examination or something else?
Lordship, the advertisement was issued on 16/3.
No, I am asking about the petitioners.
My lord.
They are university graduates.
They are Hindi university graduates. The full-time Hindi students, lordship.
How, let us see petition number 1.
My lord. It's all written in Hindi, lordships. With due apologies, I do not know how to read Hindi.
Rashtrabhasha Prasar Samiti, Wardha. Asarja in Hindi. Rashtrabhasha Prasar Samiti, Wardha. So all the petitioners are like him. All the other petitioners are like petition number 1.
I believe
This
so, lordship.
Rashtrabhasha Prasar, no, believe so is the one thing.
All of them are
Making
graduates, lordship.
confirmation,
Yes, lordship.
assertion is one thing.
Yes, lordship. All of them are graduates.
No, they are not graduates. Graduate is one thing. Equivalence of graduate is another thing. Graduation is obtained from universities,
Lordship.
recognized by the University Grant Commission. So they are not graduate. Maybe
May I take a
treated
lordship?
to be
Lordship.
equivalent to a graduate. That is the one thing. Not degree holder. Degree can be conferred by an university.
May I take a lordship?
Even say-
Yes, lordship. My lord.
Indian Institute of Management,
My lord.
right?
Lordship.
It confers diploma because Indian Institute of Management are not universities, right? They can only confer postgraduate diploma. Though persons say MBA from IIM, but they are postgraduate diplomas, not degree. MBA degree can be conferred by an university, right? So there is a difference. So they are not graduate, degree holder concept. If this paragraph 3 is correct. Anyway,
May I take your lordships to page
so
141?
what are
annexure
the
23.
provisions you have challenged? Let us see that.
Before that, my lord, on the question that my lord has raised, I beg to take your lordships to page 141, annexure 23. This is the notification issued by the government of India. Page 141, annexure 23.
Yes, my belief
My lord,
appears to be correct. 142, right?
141, lordship. Yes, the type copy is at page 142, yes, lordships.
So particulars of Hindi examination recognized by the central government. See the 4th column. Equivalent standard. So they are not degrees. You represent whom?
I'm for 47 of the private respondents.
And who is the, yes. Okay,
Now, if my lords may,
where is that particular impugned provisions?
lordship,
Let us see, have a look at.
lordship, the rule that is under challenge, the impugned rule is at page 152, annexure 31. The relevant page is at page 159.
Rule 7,
7B, Roman 4 and 5.
7B. B. Roman
4 and 5, lordship.
4 and Roman.
May I read the Roman 4, if my lords may allow me. Roman 4, the required educational qualification for recruitment to the post of graduate Hindi teacher. A, graduate, postgraduate, or its equivalent with at least 50% marks on an equivalent grade. Lordship, that language, equivalent grade, relaxable by 5% for scheduled tribe, scheduled caste, differently able candidates,
in either graduation or post-graduation with Hindi as an elective subject at a bachelor's degree level from a recognized university. So not Hindi as a full-time course, but as an elective subject, my lords may kindly take note of that. B is Bachelor of Education, BA Ed, BSc Ed from any National Council of Teacher Education recognized institution, and C, besides fulfilling the above qualification, the candidate must have cleared the state teacher eligibility test conducted by the SCERT. The same provision goes for Roman 5 also, Lordship, which is
So you fulfill which condition under 7B Roman 4?
in fact, Lordship, the first
You
point,
fulfill B and C.
A
No,
is
let us, the dispute is regarding A.
Lordship-
Dispute is regarding A perhaps.
no, Lordship. In the A, there is or an equivalent grade is also there.
We'll come to A later on.
Yes, Lordship.
Whether you fulfill condition B and condition C,
Now, as far as B is concerned, Lordship, C, yes.
that
C,
qualified.
C, we're not allowed to appear. B is B.Ed, B.A.Ed, where we don't qualify because we are not
So
qualified to
C,
apply for
let-
the course.
Let us come to C then. You are not qualified to appear.
That's because we're not allowed to apply, Lordship.
So, under the Right to Education Act, Central Act,
Lordship.
that is compulsory.
TT,
TT,
yes, Lordship.
under Right to Education Act, perhaps 2009,
Lordship.
I think Supreme Court of India has given its stamp of approval that that is mandatory. Right.
Lordship.
NCTE has also given that B.Ed is compulsory.
Lordship.
Then A, question about equivalence.
Lordship.
Equivalence of your qualification to that of graduation.
Lordship. So, Lordship, by the misinterpretation of A by the state respondents, we are not allowed to pursue for the B and C. And as far as B is concerned, Lordship, as far as Hindi course is concerned, the Hindi equivalent course of B.Ed is Parangat. And strictly speaking, going by the course, the Hindi course as a separate course, Lordship,
Who gives this equivalence?
equivalence, Lordship, that is by the Government of India's notification, which my Lord has already read at page 141, type copy at page 142.
On what ground you have challenged it? Virus?
Yes, Lordship.
Virus, you have challenged in what ground?
On the ground that
Virus
Lordship,
can be challenged under what grounds?
equality, Lordship, on equality principle that has not been applied to
There
us.
can be two grounds on
Lordship.
which virus can be challenged. Right?
Yes.
Now, what are the two grounds?
Lordship, one is legislative competence,
The other is
the violation of fundamental rights.
14.
Yes, Lordship, Article 14.
So equals are treated unequally or unequals are treated equally in the case, in this case.
In this case, Lordship, the unequals with elective subject as Hindi. The full-time course, if my lords may kindly accept this analogy. Now, for instance, Nagaland is a predominantly Christian-dominated state. We have BTH course, the Bachelor in Theology, Masters in Theology. Now, those who take up moral science as a subject, are they qualified to become pastors and reverends, Lordship? Simple as that. The same analogy also applies here, my lord. If my lords may accept my argument. The Lordship, for someone who has done all the subjects, studied
Accept
all the
or not
courses.
to
in-
accept, you will be at the end of the submission.
Lordship,
Right? To understand the basic thing, I'm
My lord.
asking you this queries.
Lordships.
So according to you that equals have been treated unequally.
Yes, Lordship.
Okay. Now this come to page 159 again.
Yes, Lordship.
These three qualifications, we are confining first. One is Roman 4, other is Roman 5. Right?
Yes, Lordship.
Now, which one, A, B, C? There are A, B, C. A, B, C. Which of these clauses you have put to challenge?
In fact, all the three, for the fact that the A, B, and C also, because the state has misconstrued
No, I am
the clause A also, Lordship.
because this C has been incorporated, not at the whims of the state. This has been incorporated. Perhaps we have to go through it under the mandate of right to education.
To that
Act.
extent, I'm not against it, Lordship. What I'm saying
Under
is.
the Right to Education Act.
Yes,
C,
Lordship.
clause
Yes,
C.
Lordship.
Clause B has been incorporated not as per the wishes of the state government. That has been incorporated under the provisions of the National Council of Technical Education Act.
Lordship.
Right. And A has been incorporated also in that manner. Right.
But-
So if you
Yes,
don't
Lordship.
qualify under B and C,
So, Lordship, the tricky situation here must be, may kindly be understood by your Lordships. The tricky situation here is that we are not taken as an equivalent. And there are two courses as far as Nagaland is concerned, Lordship, that cannot pursue for B.Ed. And that is those who are theological graduates. They cannot apply for B.Ed. They are not allowed to apply for B.Ed.
that is the education system, Mr. Council.
Yes, Lordship. Now, but here we are talking about teaching Hindi course, Lordship. Teaching Hindi subject in the schools. Now, what is the point of studying? What is the point of becoming a full-time Hindi student if we are not going to be allowed to even apply for a post, Lordship?
These courses are okay. Let us see your certificate first to understand. Rashtrabhasha Prasar Samiti. Sir, we cannot understand this page 28 onwards. That is, my position is similar to you. I am similarly situated like you in understanding what is written there.
My lord.
Right. You can make me understand page 28. What is revealed from page 28? Have you given any translated copy of page 28?
No, Lordship, should I make an endeavor to translate all the pages?
I have not understood it.
Because
To
I
be-
also, I can't understand, Lordships.
I could say that there are 3 papers. Page 28.
Lordship.
I could understand that there are 3 papers. Prashna Patra 1, Prashna Patra 2, Prashna Patra 3. I think paper number 1, paper number 2, paper number 3. Maybe to that extent. In which year he passed? And what is the name of the examination?
Petitioner number 1.
141.
He started pursuing paragraph 3 of my petition, Lordship. Some explanation is given in the paragraphs. But my Lord, may kindly allow me to read. The petitioner number 1 is currently serving as the president of all Nagaland Hindi Students Union and is also representing as one of the representatives of Parent District. He started pursuing his class 10 Parichai in Hindi in the year 2012. And class
Parichai.
12
Parichai.
COVID in Hindi in the year 2013 and graduated Radna in Hindi in the year 2015 from Rashtra Bhasha Prachar Samiti Wardha and has also completed his degree in Master in Acharya in Hindi in the year 2022 from Rashtra Bhasha Prachar Samiti Wardha He has also completed his 10+2 secular in the year 2015 and from the board of such and such lordship. My apologies, your lordship. I thought your lordship would be more proficient with understanding Hindi.
No, no, no.
Then in that case, if my lords may kindly allow me, I will try to translate all the pages for my understanding as well as for the understanding of the honorable court also on the next date, before the next date.
Yes, anybody conversant with Hindi amongst the council of the contesting parties? Anybody conversant with Hindi?
Yes, 3 certificates. 10 class, 12 class, and graduation certificate.
There's something, Samiti. No. Then Bharat Sarkar, what is this? Some maybe the one will be by a board of secondary. This is an Samiti, not an empty board. Yes, that is their decision. You can't go back and say. Everybody declares themselves. What is the division?
Translated to be one of the mark sheet translated into English to my affidavit. What is that?
Let us try to understand.
Page 22 in the state affidavit.
Affidavit in opposition by state. 1.
Page 22, this is the
One.
mark sheet.
1 minute. Okay, 1 page.
22. This is in Hindi, and the translator for copy is in English. So the translator copy is Rashtra Bhasha Pracha Samiti Wada, mark sheet Rashtra Bhasha Rahma India. And in the government of India recognized Rahma is equivalent to Hindi subject in BA. So the mark sheet itself very clearly says that Rahma is not a graduate degree. It's only a one subject for in Hindi in BA.
Your lordship, that's a misinterpretation. It's only saying equivalent. It's not one subject. There are many subjects my lords will see.
Subject in BA, but it is not a graduate degree.
Course, not subject. Course.
And they do not have years, though they have nothing. So I have stated in my who have what
Okay. Yes, then what happened? What is the advertisement?
Lordship, the first advertisement is 16.3.
Do any of these petitioners
Lordship,
has any university degree?
no, Lordship, as far as university degrees are concerned, some of them have read up to class 12, but not graduates.
Not. And
One of
they are,
few of them,
are all these petitioners are aspiring for graduate teacher Hindi?
Lordship, yes.
All these petitioners
Yes, Lordship.
are aspiring for the post of graduate teacher Hindi
Yes, Lordship.
or anything else also?
Yes, as graduate Hindi teachers, they are aspiring for
Only
that.
graduate Hindi teachers,
Yes, Lordship.
only graduate,
Hindi graduate teachers.
Hindi graduate teacher, graduate Hindi teacher.
Yes, Lordship.
Now, why you are then assailing 7B Roman 5?
5, Lordship, the same principle also applies to those in the secondary. That is why, Lordship.
No, any of these petitioners?
No, Lordship. No, Lordship.
No.
No, Lordship.
Are aspiring for primary Hindi teacher?
No, not in this advertisement, Lordship.
Not.
Yes.
So basically your challenge is mainly to 7B4,
Yes,
Roman
Lordship.
4.
Yes, Lord.
Right. 1 minute. Do you have a right to education? Do you have any, this is your Nagaland service rules. Okay. Do you have any idea about NCT?
Lordship, I have also relied on this on my affidavit in opposition. Lordship.
We are here to, Mr. Just understand, we are here to start.
My lord.
NCT regulation and right to education Act.
My lord, I have enclosed this as Annexure A in my affidavit in opposition, Lordship, affidavit for 47 of the private respondents at page number 10, Lordship.
Page number?
Yes, my lord, page number 10.
You are graduates.
Yes, my lord.
With Hindi as a subject in your graduation.
Yes, my lord. Some of
Okay.
us, we are, we have
Okay.
graduated in.
Okay.
Lordship.
Now, okay,
So-
National Council, let us see.
Lordship, by virtue of an enabling provision in the NCTE, the central government has passed its notification whereby qualifications have been given. At para 11, there is a chart where there are.
No, come to page 10.
Lordship.
Ah. Okay, come to page 11,
My lord,
rule, regulation 5.
my lord.
Whether, for us, read regulation 5. Regulation 5,
My lord.
read.
Power to relax, where the council is satisfied on receipt of reference from the concerned state government that special circumstances exist warranting relaxation of some of the provisions of the regulation, it may grant relaxation of that provision to such extent for which time period and subject to such conditions and limitations as it may consider necessary in a just and equitable manner, provided that no relaxation shall be granted under these regulations with regard to the minimum qualifications for appointment of teachers for level 3, class 1 to 8, as specified in the first schedule.
Okay, now come to the first review.
My lord.
One is serial number 3, level, primary and upper primary.
Yes, my lord.
Let us read.
Lordship, insofar as my case is concerned, I'm appearing for only the
I
the
know.
private- Lordship, so for second.
Still, I'm asking
My lord.
to read
Lordship. Secondary.
three, primary and upper.
Primary and upper primary for class 1 to 8. Minimum qualification as laid down by the National Council of Teachers Education by its notification dated 23/8/2010 as amended from time to time issued in exercise of the powers conferred under subsection 1 of section 23 of the Right of Children to Free and Compulsory Education Act 2009.
Next.
Lordship, secondary and high school for class 9 and 10. Graduate, postgraduate from recognized university with at least 50 marks in either graduation or post-graduation or its equivalent, and bachelors of education B.Ed from National Council of Teacher Education recognized university.
Or next page.
Lordship, B,
Next.
graduate stroke postgraduate from recognized university with at least 45 marks in either graduation or post-graduation or its equivalent and Bachelor of Education B.Ed from National Council of Teachers Education recognized institution in accordance with the National Council of Teacher Education form of application for recognition, the time limit of submission of application, determination of norms and standards for recognition of teacher education programs, and permission to start new course or training. Regulation 2002 notified in 13/11/2002 and NCT recognition forms and procedures regulations 2007 notified in 12/10/12/7.
Is there any specific separate provision for Hindi?
Not to my knowledge, my lord.
Okay.
Lordship. As I was saying, my lords, as far as the course of Hindi graduation is concerned, that is to be treated as equivalent. And of course, my learned friend for the state has said that it's not equal, just equivalent. I do not know how my learned friend understands, but as far as my knowledge goes, if my lords may accept, equivalent is in a different discipline. So whether they are equal or not, the subject matter to be considered by this honorable court in my respectful submission is, what subject are they going to teach? Whether we are equal to a normal
Here, question
graduate.
of interpretation is very limited,
Lordship,
Mr. Counsel.
my lords.
Equivalence is to be accorded by the state government,
Lordship.
not by the court. Court is not an expert in framing policies in respect of education matters.
Lordship.
Right? Equivalence has to be granted by the state government and the domain on the basis of the report of the domain experts. We are not going to sit over the decision of the state government. Now, anything has been notified as equivalent. Anything has been notified as equivalent, that a person having qualification from this kind of Rashtrabhasha Prasar Samiti
Recognized
without
government
having
teacher.
any graduate degree
Lordship.
can be treated as equivalent.
No, Lordship. If my lords may kindly accept my argument, if these so-called Hindi graduates to be treated as equivalent are to teach other subjects, then Lordship, I agree with the submission of the state and their affidavit in total. But here we are talking about teaching Hindi students, Lordship, the students' Hindi subject, Lordship. The question of equivalence also has to be understood from two different parlance, Lordship. We are talking about teaching Hindi subject. We're not talking about being treated as equivalent to teach other subject. I'm a student of political science. I took alternative English as my elective subject. Am I qualified to become an English teacher?
Then
That
we have
aspect
to
also has
examine-
to be
we have
considered
to
by this
examine-
honorable
We have to, that if that argument is to be accepted, then better you translate correctly all these certificates, because you have hardly in higher secondary, how much you have studied, in graduation, how much you have studied. Because in graduation, there are how many years? 3 years.
Yes, Lordship.
How many subjects one student has to appear at least in 1 year? 1 year, how much? 5 papers or 6 papers?
My lord.
Second year again, 5, 6 papers. Third year again, 5, 6 papers.
Lordship.
In graduation, maybe 15 to 18 papers one has to appear and to pass, obtain pass mark. Let us see one of the graduation, equivalent graduation certificate of your petitioners, any of your petitioners. Let us see.
Oh, my lords.
Which
without,
one is equivalent?
Without the
Somakatsa?
interpretation, Lordship, without translation, my lord, I will not be able to assist this honorable court. So
Because if this graduation, your so-called graduation, is obtained by appearing in only 6 papers,
Lordship,
only 6 papers, come to page 30.
30.
This is equivalent to graduation, yes, 30. समझ कुछ क्या है? हाँ? BA, some of that. How many paper? BA. What are the papers? Okay. This is the translation of all these papers. I cannot sketch my head. What are the subjects?
My lords, my lords.
I have read Hindi for only 1 year, class 5. So I'll not be able to understand and decipher what is written there.
Your lordships may
If
kindly
your
give me an opportunity.
entire graduation
Yes, lordships.
is only on the Hindi subject. I could come to know that some natak upanyas means drama novel is 30, right?
Lordship.
So
My-
if it is only confined to Hindi, all these papers in your graduation,
Yes, lordship.
do you have any English paper? Do you have any English paper or any
It
other
appears not,
paper
lordship.
in your graduation?
That I'll have to translate and,
Or find out from
yes,
your-
lordship. And find
whether
out from
they
my
have
clients.
studied any English paper or any other MIL paper. Like to pass graduation, you have to take 2 subjects in general also. Political science, maybe philosophy, maybe economics, maybe geography. Like that, diverse subjects, at least 2-3 subjects, plus English.
Lordship.
Whether your graduation includes English.
Lordship, it's confined only to Hindi course and teaching Hindi subjects, so I do not know.
Do you have any decision that how equivalence is granted? How equivalence is granted, how equivalence of qualification is granted? Any decision?
Lordship, as on today, no, Lordship. I am relying on the government of India's notification of 1980.
No, I was Supreme Court decision.
Besides that, I do
There
not
are
have.
many.
Lordship. I'll
There
find
are
out,
many.
Lordship. I'll find out.
That how 2 qualifications are to be accorded equivalence, right? Is there any decision on your part?
No, Lordship.
So there are many decisions that how 2 qualifications can be treated as equivalent. To my understanding, only if the state government or the central government grants equivalence, then only court can accept it as an equivalent. Court cannot. Court, my limitation I am saying, court cannot grant equivalence to 2 qualifications.
In fact, my lord, if we go by Rule 7(4)(a), Rule 7(b)(4)(a), the small a, that interpretation should not be against us because the equivalent, and that equivalence has to be read with the notification of 1988 issued by the government of India. If that is read together, Lordship, we should not be denied the opportunity to apply for a post. But just because the state has misinterpreted its own rule provisions, Lordship, we are denied the opportunity to go for 2 courses, that is B.Ed as well as even to appear for TET. Teachers eligibility.
What
test
is
also-
their answer to it?
Yes, Lordship.
What is the answer to that
My lord,
central government's
the 1981,
notification
page
by the
141.
state government?
In their affidavit, they have just bluntly said that it doesn't apply in our case because we are not to be treated as equal. But equality also, as my lords have understood, it has to be understood in 2 different manners. Whether we are asking to be treated as equal to teach other subjects, that's a different issue. Here, equality is, we're talking about teaching Hindi, and we have studied Hindi course, Lordship. It has to be separately understood, which has been misinterpreted by the state respondents, Lordship.
Services. It clearly says that it may however be clarified that the conclusion to this examination has been supported only in regard to the standard of review prescribed in the equivalent review examination. and it is not to be treated as equivalent to the full credit certificate degree of the examination for which it has been taken.
That I agree, my lord. That I agree, my lord. In the context of other subjects, here we're talking about Hindi only, lordship. But,
Yes, my brother also says that translation of these certificates are necessary, not as a part of our teaching, but you can give it
my lords.
so that we can proceed.
My lord, the exam result has been state right order dated 2/8/2022, and there is an urgency in this regard. Also, my lord, of course, my learned senior colleague has not completed, but if I am given an opportunity, I'll satisfy my lord that the settled position of law in this regard is most clear, lordship. I will be relying on the Supreme Court decision, whereby the Supreme Court has stated very clearly that the court is not to go into the technical aspects of this matter to assess the to go into technical aspects also, lordship, and also from the bare reading of the petition of the petitioner, from the appreciating it from the chronological order, it is clear that some of them have undergone Ratna when they were in class 10, when they were in class 12. So whether a person can be considered graduate without passing class 10, without passing class 12 also, lordship, this is something that is apparent, my lord. And therefore.
And what about this TET and NCT? This B.Ed is compulsory.
Lordship.
And to undergo B.Ed.
Yes, my lord.
Graduation is compulsory.
Lordship.
Are you eligible to undertake B.Ed course?
No, lordship, we are not
No.
allowed to, yes.
Then what is your locus then? To
No,
go
lordship.
deep into the virus.
Ours is Parangat, lordship. Parangat.
And you are with Parangat, you are not eligible to undertake B.Ed course. You are not eligible to undertake to sit in state examination. What kind of qualification you have? If your central government have treated you as equivalent, then you are not eligible to sit in TET examination. You are not eligible to undertake B.Ed course. What kind of course you have?
Then lordship, that is where the role of the court comes in respect.
No, equivalence. There are about 100 decisions. Equivalence of qualification is not the function of the court. It is the central government or the state government who can give and accord equivalence to two qualifications. Go through any judgment of the Supreme Court, right from the establishment of the Supreme Court up till now. That court does not have the expertise to sit in appeal over decisions of expert bodies, and more particularly in respect of educational matters. Am I clear?
My lord.
More particularly.
In fact, I appreciate the help of your lordship, but at
So,
the same time, lordship, here.
Try to find out an exception from that.
Lordship.
I don't have, because you are, even if it is so treated as your qualification is equivalent to a graduate examination, then why you are not eligible to undertake a B.Ed course? And why you are not eligible to sit in TET examination? Both are compulsory. You cannot.
No, lordship. In other words, that is where I'm
Show me.
respectfully submitting, lordship.
First,
Yes, lordship.
you have to establish that you are eligible to undertake B.Ed course also with this degree. Nobody has that because you don't have degree. Otherwise, you don't have any degree qualification from any university. Now, with possession of this qualification from Rashtra Bhasha Prasar Samiti, which according to you is equivalent to a degree, then why central government has not permitted you to get admission in B.Ed degree course?
Lordship. I will
If
need to
you
do
have
little
been
more research,
treated
my lord. Yes, lordship.
as equivalent as a graduate
Yes, lordship.
by the central government.
Lordship.
Now, why central government has not permitted you to undertake B.Ed course for which a graduate degree is only the necessary
As far as
qualification?
the central government is concerned, lordship, I'm
That
not aware.
defies logic.
That I'm not aware, lordship, as far as the central government is concerned, but within
Show
the
me.
state of Nagaland, lordship,
Show
we are
me.
not permitted.
Show me
I will find it,
that
lordship.
central government has permitted
Lordship,
this Rashtra Bhasha
Right.
Prasar Samiti equivalent to graduate to undertake B.Ed course. Then it is clear.
Lordship,
PE posts that are being stayed by this honorable court. And so the schools are suffering because of the, this is, Lordship say, the Lordship-
Okay, we can take up, we can take up this Wednesday also.
If we presume the petitioner has a graduate degree, if Ratna is equivalent to a graduate degree, then also he does not have a BA. So
We cannot say so
Yes.
unless. I have seen,
You know, on a basis of Kohima, the only three of them that have graduations with Ratna, but without BA. So where is the locus to challenge the violence of this one, the service rule? So Lordship, I pray that the nothing make effect with the, for the interest of.
my brother will not be available. There is a problem, difficulty is.
Yeah.
He is also after tomorrow, second half, he is going out. Not in benches, someplace else. Okay, next Wednesday we can take up. I'll be here.
my lord. Lordship,
Get the English translation. Show me, established by authority of law, that central government has permitted a candidate who has a
Madam.
qualification equivalent to graduate as per your certificate,
I have taken note of it, my lord.
take admission for B.Ed
Lordship.
course.
Lordship,
That will cleanse the issue that your qualification is as good as graduate.
my lord.
Am I clear?
Yes, your lordship.
Then that will also cleanse the issue that you will be eligible to sit in TET.
My lord.
But even then also, since you do not have the qualification, then if suppose you fail, then your locus will come under cloud. But if you can establish that A 7B Roman 4A
Is in my favor.
is in your favor, still I think you are not in a position to challenge the advertisement. Maybe you are successful in 7B Roman 4A, but you will not be in a position to challenge B and C, because those are compulsory and mandatory and given approval by the Honorable Supreme Court of India.
But that will have a direct impact on B and C also, if I qualify for A, lordship.
Then you have to wait for 2 years to complete your BA degree.
In other words, lordship.
Those, Mr. Council, get those decisions of the Supreme Court. TET is compulsory. Supreme Court has given stamp of approval, and B.Ed is compulsory as per the NCT regulation.
Even for Hindi course.
Even for
Yes.
all course,
All courses.
all,
Yes, lordship.
any intermediate teacher or a graduate teacher must have, for intermediate, that is a different degree. And find out a recent judgment
Find out, lordship.
where B.Ed, that, what is the rule? 159. This DL, come to 159. DLED for primary Hindi teacher.
Yes, lordship.
DLED. This qualification is also, even if the B.Ed degree is higher, even if the B.Ed degree is higher, B.Ed degree can be undertaken by a graduate. This DLED,
With regard to the primary.
Supreme Court has said, this qualification, even though B.Ed degree is higher qualification, B.Ed degree, but B.Ed degree cannot be treated as equivalent to DLED. So a B.Ed degree holder cannot be permitted to apply for primary teacher. he must have to pass BL. Supreme Court recent decision.
Yes,
You find out.
My lord,
So equivalence is a very tricky situation.
lordship.
It has to be given by the state government or UGC like that.
Lordship.
We, myself and my brother, cannot give equivalence unless you establish from documents that these are treated to be. You have to establish from documents. We are not in a position to interpret.
As
Am
far
I
as
made-
documents are concerned, respectfully, my lord, I believe I have
See,
the documents.
right from the establishment of the Supreme Court
Lordship.
or this High Court, whether a court has granted equivalence to two qualifications.
Lordship.
Bring one decision, we'll examine.
My lords.
Otherwise, there are about 100 decisions against you.
I'll find out, lordship.
We cannot sit in appeal over decisions of experts, more particularly in the academic.
Lordships.
Okay. Heard Mr.
Joshua.
J. Sheki, Learned Counsel for the petitioner. Ms. Fish Supri, Learned Additional Senior Government Advocate, Additional Advocate General, Nagaland, for the state respondents. And Mr.
Alezokiri.
Learned Counsel for the private respondents. As sought for by the Learned Counsel for the parties, release the case in the next week. I have given the boundaries.
I believe I have understood, my lords. Oblige your lordships.
For admission, item number 6.
Yes, Mr. Counsel,
May it please,
why
my
it
lord.
has come?
My
Is
lord,
it
this-
admitted?
Yes, my lord. It has been admitted by order dated 22/3/2023.
So it will come for admission hearing. LCA received.
Yes, LCR is here, lordship.
Yes, public prosecutor.
In fact, yes, it is ripe for hearing, my lord.
Okay. Heard Mr.
Sandhya.
Santianger, Learned Legal Aid Counsel.
Yes, my lord.
Okay. For the appellant and Mr.
Kiyankami.
lordship.
Kiangami, Learned Public Prosecutor. Learned Public Prosecutor Nagaland. For the state respondents. Full stop. As the appeal has already been admitted for hearing. And LCR
Yes,
reconstructed
yes, my lord.
LCR.
Yes.
Sufficient. Have you gone through?
Lordship, not sufficient, but it's no more available. So much exercise is being carried out.
Okay. What are materials available? Extract of judgment, apparent, confessional statement. Statement of. Any of you has in your possession the depositions of the witnesses, PWs or DWs?
No, my lord.
No. So
This is a 2003 case.
appellate court has to base its decision only on the basis what is reflected in the judgment. LCRs are not available, meaning there are depositions of PWs, prosecution witnesses are not available. In the judgment, something has been reflected. The appellate court has to. How to do it? In terms of, see the office orders. Is the court constructed with available materials collected from the crime branch. So has been received by the registry from this record is placed with the instant copy of the forwarding letter of the district application of the state to this point marked as flag C. Flag C. When the impugned judgment was rendered? 2004.
Yes, my lord, on 1st of October 2004.
Oh, that was by additional deputy commission.
Yes, my lord. Later on, the
Okay.
name was changed to District and Sessions Judge. Earlier, it was.
But judgment was delivered by additional deputy commissioner.
Yes, my lord. The nomenclature was used as such earlier. ADC judicial.
So he is not judicial officer perhaps.
Judicial lord.
He is a judicial officer, my lord.
Traceability of the record would be doubtful then. I don't think. Whatever is available, we have to proceed with that perhaps.
So much efforts have been made, my lord. By the courts also, by the police, but the records are not traceable anymore. And the appellant here, my lord, he has been continuously in prison for more than 20 years.
Life.
Yes, my lord.
Life imprisonment means 20 years. Last week or within last 10 days, Supreme Court has said
My lord,
that life imprisonment means 20 years.
my lord, my lord. Yes,
Do we have the
I don't have
Okay.
the order, lordship, but lordship, here substantial law has been misinterpreted. And lordship, he could not have been convicted under 376, lordship. But he was convicted.
The question is, if you can get hold of that order,
Yes, my lord.
we can release him on bail immediately.
My lord, then in that case, lordship,
Find out that decision that life imprisonment means
20
20 years.
lordship.
Since this appellant has already served 20 years,
Yes, my
let
lord.
him be released on personal bond. We
Lordship.
can decide the appeal later on. What do you say, Mr. Counsel?
Then in that case, lordship, if it can be listed.
Very,
next week-
within 10 days, last 10 days,
Lordship, I'll find it out, lordship.
find out.
I'll find it out.
Don't ask me to find out.
My lord, my lord.
I'll try to find out. Have to answer. We'll find out.
Lordship, if the matter can be listed again on 22nd.
I mean, let me try now itself. Now itself,
My lord,
there is a proverb.
my lord.
कल करे तो आज, आज करे तो अभी.
Lordship is absolutely right.
Lordship, it is Matan versus State of UP, 2023 SCC online SC 1473.
Get a copy of this when it is down.
My lord,
Mine it is down. Get a copy of this.
my lord,
We'll get it listed on next Wednesday.
my lord,
If 20 years is 20 years,
my lord,
life is 20 years, then you are entitled for bail.
my lord.
Then we'll try the appeal later on. Okay, list and the case in the next week. Before the revision means in the next week. Get copy of this order.
My lord, I will. Highly obliged.
Give it to the court master so that I can find out and read it in the meantime.
My lord.
For orders, item number 10.
Yes, Mr.
Yes,
Counsel.
your lordship, I am respondent number 3, 4, and 5. Your lordship, the appellant, after filing these appeal petitions, the council for the appellant, they have withdrawn their wakalatnama. Your lordship, as per the direction of this honorable court, the retirement notice was served to the appellant. Again, on the last occasion, your lordship, the honorable court has served a notice through the police station where the appellant resides, and the service is also completed. Your lordship, the
So
appellant
this is RFA.
Yes, you.
Okay, this RFA can be dismissed on for default.
Yes, yes, your lordship.
Criminal appeal cannot be dismissed for default.
Yeah.
A criminal appeal cannot be dismissed for non-prosecution.
Yes,
Now
yes.
this
your
is regular civil
Yes,
appeal.
Yes,
What
your
is the law? It can be dismissed for non-prosecution.
Yes, your lordship. Yes, your lordship.
Brother? Can it be dismissed for non-prosecution? Where is it? Huh? Ah, can you cannot do that?
Your lordship, my prayer is, your lordship, after filing this appeal petition, from the so many months, they are never appearing the court and wasting the time of the court and this. So your lordship, it can be dismissed with cost, lordship.
Oh, who will find out? You go, you undertake that guarantee that you will recover the cost. I'll direct after recovery, deposit to the registry of this court so that it can be deposited in the advocate benevolent fund. You take the guarantee.
No, lordship.
The recovery, I will direct recovery of 5 lakh. You recover it and deposit it in the advocate benevolent fund of Nagaland Bar Association.
No, lordship.
Then don't make such submission then, which is not possible to be. None has appeared for the appellants today on call. When the appeal was listed, on the previous date, 17/5/2023. Right? None had appeared for the appellants on that occasion also. First off. On 17/5/2023, the court directed issuance of notice to the appellants. Single appellant or two? Appellants. Through the officer in charge, East Police Station, Dimapur. And the officer in charge, East Police Station, Dimapur, was directed to file a report thereafter comma, after service of notice upon the appellants. Full stop. This court. Okay. Record. Today on call. When the appeal was listed, on 75, huh? It will give it. On 8/11/2023. The appellant was found unrepresented, whereas Mr. YP Gupta, learned counsel, appeared on behalf of the respondent number 3, 4, and 5. Full stop. On 8/11/2023, comma, this court, on the basis of the report received from the officer in charge, East Police Station, Dimapur. This court received a report from the so-and-so stating that the service of notice upon the appellants had been affected. Full stop. A letter dated 19/10/2023 of the officer in charge, East Police Station, Dimapur, addressed to the Deputy Registrar within bracket Judiciary Gauhati High Court, Kohima Bench, Kohima, was also perused, wherein the officer in charge, East Police Station, Dimapur, reported that service of notice upon the appellants were duly affected. First of all, this court had on 8/11/2023, observed that appellants were deemed to be served. Full stop. And posted the case for today for necessary orders. Full stop. Mr. YP Gupta, learned counsel for the petition, respondent number 3, 4, and 5 is in attendance. Full stop. In view of service of notice upon the appellants, it is evident that the appellants are aware of the proceedings of the appeals. Full stop. Appeal. Even prior to 18/5/2023, the appellants were found unrepresented on a number of occasions. In such obtaining fact situation, this court, it appears to the court that appellants are not interested to pursue the instant appeal. Consequently, the appeal is dismissed for non-prosecution.
Much obliged.
For orders, item number 12.
This vote by order dated 7/12/2022.
By order?
7/12/2022.
7/12.
Of Director, the to take fresh step for service of notice upon respondent number 11 and 12. So accordingly, we have taken a step and we file our affidavit on 16/12/2023.
16/12.
Yes.
Hard MS P. Shukri Learned Edition, well, Advocate General Nagaland. For the appellants,
Respondent 1 to 10 and 13.
MS
Certificates or no?
Learned Counsel for the respondent number 1 to 10 and Mr.
I'm for respondent number 18 to 22.
Mr.
V. Koza.
P. Koja. Learned Counsel for the respondent number 18 to 22.
Lordship.
You represent also 17,
Yes, Your
13 to
Lordship.
17
Yes, Your Lordship, 1 to 10 and 13.
and 30 to 70. Those two. The appellant by order dated 7/12/2022, the appellants were directed to take first steps for service of notice upon the respondent number 11 and the respondent number 12 by way of trustee, and to file a compliance affidavit thereafter to that effect. To stop. An affidavit on behalf of the appellants has been filed on 19/12/2022. Post office.
16.
It is stamped as 1912. As per the statements and environments made in the said affidavit, the appellants had accordingly taken first steps for service of notice upon the respondent number 11 and the respondent number 12 by way of the state, and the notices were duly served upon them post office. As per Annexure 2 and Annexure 3 to the said affidavit. It transfers from Annexure 2 and Annexure 3 to the said affidavit that the notice says were received by the respondent number 11 and the respondent number 12 respectively. In view of the above, the notices upon the respondent number 11 and the respondent number 12 are service of notice upon the respondent number 11 and the respondent number 12 are held to be complete. As the notices have been duly served upon all the respondents, and the other respondents, save and except the respondent number 11 and the respondent number 12 are duly represented by their learned counsel, lays the case for admission.
The lieutenant will come up on 13th of December.
Lays the case in the admission column on 13/12/2023, as sought by the learned counsel for the parties.
For hearing, item number 17.
Yes, something was said.
Yes, Lordship, on behalf of Mr. Penawafang, the council put a CBI has
Yes.
sought for 2 weeks' time for adjournment. That was subjected by my learned friend. Now what happened was, why CBI was implemented as a party? Before the NIT was issued, before the work order was issued, the work commenced and then started executing. There are evidences on that also, materials to show that. Secondly, a huge amount has been released before execution of the works. And
Huge
then,
amount.
yes, NIT that in the NIT, in the process of NIT, the financial bid was open in absence of the contractors. Therefore, the writ petition was filed by the aggrieved landowners, and CBI did not, and because of that, CBI was also implicated as a party respondent. And in the writ proceeding, the CBI was not interested to contest initially, although they have filed affidavit. In the writ appeal, Mr. Y.P. Gupta appeared for CBI at one stage, but then as per the CBI Act, the CGC cannot represent the CBI. Lordship knows that the prosecutor is to be appointed. By that time, Mr. Benawapang's term was not extended. Now that the term of Mr. Benawapang has been extended, apparently, that is how he got the instructions to appear on behalf of the CBI. And on his behalf, another counsel has sought adjournment for 2 weeks. That was the stage when my learned friend has
Yes,
objected.
who was the counsel who made the mention? You made the mention. Okay, can it be possible for him to appear next Wednesday?
Next Wednesday, Lordship. Some difficulties today, so Lordship may kindly.
Since he is expressing some difficulty.
You know, if it is to be postponed today, then next Wednesday, whether they come or not, let it be.
Yes.
I'll be there, I'll remember that.
Because now season has come for execution of the whole again.
Mr. Siti Jamil as senior counsel for the petitioners and Mr. R. Yalul as
Appellants.
senior appellants. And Mr. R. Yalul and counsel for the private respondents. Private respondents
Number 4,
are present. Respondent number 4.
yes.
Okay, are present. Mr. Joseko Poti, Learned Council, appearing for
Benawapang.
Bena Wapang,
On behalf
On
of
behalf
Mr.
of-
Benawapang,
on
counsel
behalf
for the
of-
CBI.
on behalf of Bena Wapang, Learned Public Prosecutor, CBI, has submitted that Mr. Bena Wapang has some personal difficulty today, and the matter be listed in the next week. First up, as agreed to by the Learned Council for the parties, list the case before in the next week, before the division bench. Before the division bench, in the next week.
Obliged, Lordship.
For hearing, item number 20.
You have received instructions? Yes,
Yes, Your Lordship. And,
shall we
in fact,
proceed?
Lordship,
What is the subject matter?
Your Lordship, the brief fact of the case is that the petitioners were appointed as on grade 4 basis under the medical department, grade 4 Bokchong district. As medical attendants and peons, etc., Your Lordship. Now, in 2012, their pays were held up. In 2012, pay was held up on the ground that they have been appointed without sanction post. And then the matter was referred to the Vigilance Department for inquiry. Then immediately after the petitioners the pay was held up. What happened was they appointed the private respondents. And in 2015, the show cause notices were issued to the petitioners. The petitioners submitted reply to the extent that if we have been appointed without vacancies, then how can the department appoint after our pay is held up again, others are appointed. So it is unconstitutional. Now,
Ultimately, in 2015, the services of the petitioners were terminated. While those who were appointed subsequently, they have been retained and they are continuing in service up to date. And now the petitioners approach this honorable court by way of the writ petition. This on the learned single bench held that since we were appointed without any vacancies, the subsequent appointments of the respondents, we cannot challenge. We have no right against that. The government has every right to appoint others subsequently.
The
That is
others
that.
were appointed pursuant to any selection process.
No selection process. All of them similarly with the petitioners on.
Similarly situated.
Yes, similarly situated. So my case is that they go take, if we were appointed without vacancies, then in that case, the case of the state is that even their case, there is no vacancies, but because of exigency of service, they were appointed. That is the case of the state respondents.
Now, in
Now,
appeal,
Yes.
what is your prayer?
My prayer is that if that is the case, then it is a case of juniors replacing seniors. Juniors being retained and seniors being let go, or alternately ad hoc replacing ad hoc, which is not permissible. That is my.
Where is the judgment of the single bench?
Page 385, 385 it starts.
Page
385. The operative portion starts from paragraph 21, 414.
Now here, all these private respondents have been served.
Yes, Your Lordship.
Let us see the order.
Starting from order dated 25/11/2020, Your Lordship, fresh steps were taken.
How many appellants?
Tenants are 18, Your Lordship. Altogether. 19, Your Lordship.
Where is the relevant operative part you want to say?
Starting from page 414, Your Lordship.
You have been served so-called notices.
Your Lordship.
You have been served so-called notices
Yes.
prior to termination.
Yes, we have submitted
So-
our replies stating all those.
So for the violation of the principles of judicial justice,
No.
that is not there.
No, Your Lordship. My ground is only on the issue of ad hoc replacing ad hoc.
Okay. Okay, start from paragraph 13. (408).
Yes. Your Lordship.
Paragraph 13, Your Lordship,
Mm.
if I may read it. Mr. Commoner then submitted that if the petitioners were to be removed from service, those who were appointed after them should have been removed first according to the principles of first come, last go. The learned counsel further submitted that the petitioners should have been retained at least on ad hoc. The learned counsel further submitted that the termination order of the petitioners issued by the respondents were illegal because it was issued with retrospective effect, depriving thereby the petitioners benefit of their past services. Furthermore, the learned counsel submitted that in the inquiry conducted by the Vigilance Commission in gross violation of the principles of natural justice, no chance of being heard was given to the petitioners. Therefore, the whole process taken up by the respondent for removal of the petitioners from service was illegal. Lastly, Mr. Tombo Bonner submitted that the respondents were directed by this court in the writ petition filed earlier to pass speaking order, but no speaking order was passed. The learned counsel continued and submitted that the decision of the state government is quasi-judicial. Therefore, reasons must be given, especially when it relates to removal of government servants from service. The learned counsel, in support of the submission, cited the decision of the Honorable Supreme Court in the case of Grandy Associates Private Limited and another versus so-and-so, recorded in 2010-9 SCC 496, the relevant para 47 and 48. The learned counsel also referred to decisions of the Supreme Court in case of P.A. Linga Reddy and others versus Karnataka. So-and-so, 2015-4 SCC 515. Para 25 to 26. The relevant paragraphs of the two judgments mentioned above are reproduced herein below, one after the other. This is with regard to reasons, Your Lordship, if I may skip it. Paragraph 17, Your Lordship. Mr. K. Sima Leonard, Senior Additional Advocate General, appearing for the state respondents, defended the dismissal of the petitioners as follows. At the very outset, the learned Senior Additional Advocate General submitted that the principles of law submitted by the learned counsel of the petitioners are not disputed, but those principles will be applicable only if the petitioners can justify that the appointment were legal and that they have enforceable legal rights. The learned Senior Additional Advocate General went on to submit that the petitioners have no enforceable right, elaborating his submission. The learned Senior Additional Advocate General submitted that the petitioner's appointment was illegal as they were appointed without sanction boards. Therefore, no writ can be issued to enforce your claim. The learned Senior Additional Advocate General further submitted that the petitioners did not challenge the appointment of the persons with whom they claimed to have been similarly situated, and they did not make them party in the case. Moreover, they cannot claim equality with people whom they admitted were also illegally appointed. Equality under Article 14 of the Constitution is a positive concept and not negative concept. The learned Senior Additional Advocate General submitted that the doctrine of reasonable classification can be invoked only if the petitioners can prove that their appointments were valid. Otherwise, the principle of law relied upon would not be applicable. The learned Senior Additional Advocate General also submitted that the case of the petitioners is covered by the judgment passed in WPC number 105K of 2015 as the facts and circumstances of the petitioners in this case and in that case are similar. However, if this court has a different opinion, the matter can only be referred to a larger bench. Thereafter, the learned Senior Additional Advocate General submitted that the petitioner's challenge in this writ petition includes a report of the Vigilance Commission on the basis of which their services was terminated. However, the Vigilance Commission Department, who authored the report, have not been arraigned as a party. The learned Senior Additional Advocate General drew the attention of this court to a letter dated 30/4/2014 of the Principal Director addressed to the Chief Medical Officer Woka Kifuri Mokokno, Zenebuto, Mon, Longling, and Timabo, and pointed out that 33 members of staff under Chief Medical Officer Mokokno were identified as appointed without sanction posts. He then submitted that the petitioners were among those 33 staffs. Therefore, an inquiry was conducted by the Vigilance Commission and Anti-Corruption, and it was based on the report of the Vigilance Commission that the petitioners were dismissed from service. Therefore, the petitioners have no case at all. The learned Senior Additional Advocate General submitted that considering the petitioners' claim for salary for the period they have worked, this court may pass appropriate order as a division bench of this court in WA 11K of 2017, arising out of WPC number 105K of 2015 and WPC number 133K of 2015 has allowed the prayer of similarly situated persons. Mr. Sima also submitted that the persons who were appointed after the dismissal of the petitioners were appointed against non-sanctioned posts and on ad hoc to meet the exigencies and with the approval of the government.
Therefore, the submission of the petitioners that their appointment shows that there was sanction boss is without any basis. Lastly, Mr. Kohima submitted that since the petitioners and the persons appointed after them were appointed under different circumstances, the plea that a talk cannot be replaced by another a talk will not be sufficient.
Which page you were reading? Page? 441?
413.
3.
Yes, 413.
Yes.
The last paragraph of paragraph 17. Mr. Sema also submitted that the persons who were appointed after the dismissal of the petitioners were appointed against non-sanctioned posts and on ad hoc basis to meet the exigencies and with the approval of the government. 18, Your Lordship. Mr.
Yes.
C.D. Jamir, learned senior counsel appearing for the respondents. Number 8 submitted that he is in agreement with the submission of the learned senior additional advocate general. Therefore, it would be more of a reputation if he has to submit any further. However, the learned senior counsel submitted that the appointment of the respondent number 8 in no way affected the petitioner's right. Therefore, their case against the respondents has no basis at all. The learned senior counsel further submitted that the writ of mandamus can be issued only when a petitioner in a writ petition can show that he has legally enforceable right and his right has been violated or illegally taken away. However, in this case, since the petitioners have not shown that they have any legally enforceable right, the right of mandamus would not lie. The learned senior counsel further submitted that the petitioners should be able to show that they were appointed against sanctioned posts, but since they have failed to do so, they have no legally enforceable right. 19. MS Easter, learned counsel appearing for the respondents number 6 and 12 submitted that there is no reason for interference on the appointment of the respondent number 12, since the petitioner has already submitted that they have no longer any grievance against his appointment. The learned counsel also submitted that in regard to the appointment of the respondent number 6, it was on land ownership basis. Therefore, she and the petitioners are not similarly situated. Moreover, her appointment was not against any of the posts held by the petitioners. Therefore, the petitioners cannot have any grievance against it. 20. Mr. Subhamwati Walin, learned counsel appearing for a respondent number 7, submitted that the respondent number 7 was appointed against a clear vacancy arising due to the voluntary retirement of his father. Therefore, his case stands on different footing than the case of the petitioners. 21. Perused that document filed by the petitioners and considered the submissions of the learned counsels of all the parties. I have also gone through the judgment submitted by the learned counsels. The most important issue involved in this case is whether the petitioners were appointed against duly sanctioned posts or not. By going through the appointment regularization order of the petitioners, I find no mention made regarding the sanctioned order number of the posts against which each of them were appointed regularized. It is normal practice that whenever appointment orders are issued, the sanctioned posts against which such appointments are made are mentioned. Since in the case of the petitioners, no such mention is made prima facie, it has to be accepted that they were appointed without posts. Therefore, it becomes their burden to prove that they were appointed against sanctioned posts. The burden has not been discharged by the petitioners satisfactorily. The argument of Mr. Tombo Corner, learned counsel for the petitioners that right after removal of the petitioners, some other people were appointed. And that shows that there were sanctioned posts and the petitioners were appointed against such sanctioned posts does not hold much water. Because the learned senior additional advocate general, Mr. Kohima, has submitted that the persons who were appointed after the removal of the petitioners were appointed against non-sanctioned posts and on ad hoc basis. Secondly, existence of sanctioned posts at the time the petitioners were appointed will not make any difference unless each of them were appointed against specific sanctioned posts. Unless the petitioners prove that there were vacancy and they were appointed against specific sanctioned posts, their claim that their legal rights have been violated has no basis. And when they have no legal right, no mandamus can be issued. Further, on perusal of the report of the Vigilance Commission and the other related documents, I find no reason to doubt on the findings made by the Commission. It appears to me that thorough inquiry has been conducted before arriving at a conclusion. As such, there can be no other conclusion than this, that the petitioners were appointed without sanctioned posts and therefore their appointments were illegal. The second issue involved in this case is whether the petitioners were given chance of being heard or not. By their very admission, the petitioners were given chance of submitting representations after representations, besides appearing before the vigilance police. Their representations were also submitted after a show cause notice was given. The perusal of the show cause notice and the representations submitted by the petitioners shows that a sufficient opportunity was given to the petitioners to submit their case. Therefore, the plea of the petitioners that they were denied the opportunity of being heard does not appear to be correct. The third issue involved is whether by applying the principle of first come last go, the petitioners could have been retained on ad hoc at least since they have been appointed, regularized in service right or wrongly. As already stated while discussing the first issue, the petitioners have no legal right over the appointment since the same was illegal. Therefore, they could not have been retained on ad hoc in preference to the newly appointed persons. The appointment of the private respondents has nothing to do with them. The government has the power or right to appoint to meet exigencies, and that has nothing to do.
Just pausing for a moment.
Yes, Your Worship.
It transpires that your appointment was shown as regular.
Yes, petitioners number 1 and Your Worship, petitioners number 1 to 4 were appointed on contingency basis initially. Then what happened was in 2009, it was converted to temporary. It was converted to temporary. And all the others were also appointed the other petitioners were appointed on temporary basis. But they are saying that it is regular. The appointment orders are very clear. It's temporary. The other subsequent appointments also are similar. Or even the other appointments are similar.
If you come to that page 303.
Yes.
Whereas on thorough scrutiny and examination.
Yes.
On regular appointments made against the different health units under so-and-so, it was observed that regular appointments were made without sanction post.
Yes, Your Worship, that is the case. But the appointment orders say that they are temporary.
Where is this? Show me a specimen.
Your Worship, I'll take Your Worship through that. Starting from page 85. The appointment of the petitioner number 1 to 4 are very clear. It is contingency initially.
And show me the appointment of private respondent.
Yes, subsequent private respondents, Your Worship. I'll take Your Worship through that. Page 143, Your Worship. Page 143.
Private respondent.
Yes, private respondents. It starts from 001, which is page 140. Page 141, it starts from. But the clean copy is 143. It's
140?
143, page 143, but it starts, actually their appointment order starts from 141. Now I'm taking Your Lordship through that.
This was reappointed somebody.
Yes, they are saying it is reappointment, but it is not. It is a direct appointment. They have admitted that in the petition. They are showing that it is reappointment, but even this was obtained by way of, Your Lordship, RTI, Your Lordship. RTI applications were made for appointments made between 2012 to 2014, and the letter whereby all these orders were furnished is at page 140, Your Lordship. Page 140 is the.
Is?
Page 140 Your Lordship, 140, Annexure 01. This is dated 15th May 2014. Detailed information of fourth grade regular appointee and ad hoc appointments between 2012 to 2013. Reference to your application for information under RTI Act 2005 dated 8 May 2014 received by this office on 8 May 2014 at 11:40 a.m. As desired by you, I am submitting herewith detailed information of fourth grade regular appointee and ad hoc appointed between 2012 to 2013 under medical officer, Chief Medical Officer Mugok Chong. So they have these are direct appointments made, though in some cases it is shown that they have been reappointed.
No, in my order mentions also somewhere ad hoc.
Yes, below your Lordship, page, in some case it is, say, page 142, your Lordship, at the last paragraph, it is purely on ad hoc. But
So
you-
on
Yes.
petitioner side, how many appellants? 18.
19 of them, your Lordship.
19. They were
19.
appointed in what kind of post?
All grade 4 in medical attendant, some beyond.
Right,
Yes.
no, what is the nomenclature?
Your Lordship.
What is the nomenclature of the post?
Some are called medical attendants, some are beyond, some are chokidars, your Lordship.
Okay.
But all of them,
So medical attendant in a
Yes.
particular hospital or,
yes, at a
Health center.
particular, yes. Yes.
right.
Substandard.
After your termination of this private respondent, any one of them is appointed as
No, not
medical?
as,
Huh?
it is not shown as replacement, your Lordship. It is not shown as replacement.
Some other
Yes,
place,
but some other places.
some other places they were
Yes, but
appointed.
within the district only.
But
Yes,
some other
yes,
places,
Yes, 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 your Lordship. Some other places, yes. But
not
within-
in the post
in,
according to your appointment order.
no.
Suppose you are appointed as a medical attendant, so and so primary health center.
Yes.
So after your termination,
Yes, your Lordship.
whether this private respondent has been appointed in that post,
Many of them were appointed in other places altogether in a bunch, in one,
Right.
but not in the same, against the same, because it is not shown that they
right?
are
So
appointed
it
against
is
the
not
same-
that
Yes. No,
ad hoc
yes, your Lordship.
is purely replaced by another ad hoc.
Your Lordship, yes. As per, yes, what your Lordship is referring to is, yes, but
It is not
these are grade 4 posts. that
right.
They can
No, not
place
a
them
post
in
to
any other
exercise.
places they want.
So it is not purely ad hoc replaced by ad hoc. And both are flowing or whatever
Yes,
is in the same. Both are not, you are seeking not positive. My termination as was affected due to the illegal nature of appointment or irregular nature of appointment, because it was to be preceded, there was no post. There was no post.
yes, your Lordship.
That is what the single judge has observed.
That is what the single bench has observed. Yes.
So your termination came about due to non-existence of post
That is what.
and your appointment in a non-existent post.
That is what they are saying.
Single judge has arrived and single judge has said that you have failed to dislodge that position.
Your Lordship, I have made representations.
There is no post, there was no post.
Your Lordship, yes.
Like I said that
Yes.
the single judge has not found any violation of the principles of natural justice. Because termination was preceded by show cause notice
Yes,
and opportunity to submit a representation.
yes.
So that aspect is not to be dealt with. Now, only thing remains that the other submission that you have been replaced by another ad hoc,
Yes.
that is also not
Your
directly
Lordship, yes. If-
appearing from the record. So basically that since I have been terminated, you've been given the benefit of salary till your termination.
Yes, Your Lordship.
So basic only issue that remains is that they should also be terminated.
Yes, and if they are to appoint, we should also be given equal.
That locus
opportunity
is,
To appoint, because.
that locus is, single judge has negated that locus. And here is a statement that this have been made with the approval of the government. Ad hoc. They have been appointed as ad hoc with the approval of the government in exigency of service.
That is what they are saying.
They are saying.
Yes.
Whether there is government approval.
Your Lordship, I have made specific in my reply to their show cause notice. I have mentioned all their appointments also, that these appointments have been made, but they have not given any justification whatsoever, that they were not neither in replacement of the petitioners nor
No, learned additional advocate general, there was a submission, right?
in his affidavit, he has made a statement. But in my reply to the show cause notices, Your Lordship, I have highlighted all these things.
There is a categorical statement according to the state.
Yes, in the affidavit only, Your Lordship, in the affidavit only, but not in against my.
With the approval of the government.
That is what they are saying, but in my reply to the show cause notice, Your Lordship.
Where is the affidavit?
Where
is the statement?
Page 263, Your Lordship.
Paragraph.
Paragraph, page 266, Your Lordship, subparagraph 7 of paragraph 3.
Paragraph 3.
Yeah, paragraph 3, and it's under page 266, Your Lordship. It has paragraph 3 has subparagraphs, Your Lordship. The last subparagraph, Roman 7. Page 266.
Contingency basis.
That is what they are saying, but the order reflects otherwise, Your Lordship. The order reflects otherwise. The appointment order reflects
14.
otherwise.
They have annexed their appointment letter.
Yes.
Where is that? 0. Where are those?
No, they have pointed in the paragraph, they have pointed to annexure 01 to 014 to the writ petition.
Yes.
Yes, so that I have taken your lordships through earlier, yes. These are the annexures. It starts from 142 onwards.
(142).
Yes, it's starting from 141 onwards, Your Lordship, but then orders are different.
141 is, yes, reappointment.
Yes, reappointment, and then, but they have admitted that all these are fresh appointments. Fresh appointments only, subsequent to.
Ad hoc.
Yes, your lordship. And in some cases, it is pure temporary, your lordship. 143, it is temporary, that is, if they are saying that it is regular, then it is a regular appointment, your lordship. 143. One 44 also same, your lordship. These are not contingency appointments.
But these are appointments made somewhere else, not.
No, your lordship.
So.
But within the same district, because district-wise appointments are done, your lordship. In the, especially when it
They are
comes-
likely to meet the same fate like you.
Your lordship, they have now continued from 2012 onwards.
And you continued for how long?
More than 10 years now.
You continued 10 years.
Yes.
You people?
1 to 5 were appointed in 2004. Then the others were appointed. Yes, the others were appointed in 2008 and 9.
So
And then-
ultimately terminated in 2015.
2012. Yeah, 2015. Yes. But in 2012, their appointments, their pay was held up. In 2012.
That was.
Yes,
granted.
yes. And then after their pay was held up,
That
they
was-
started on the ground that there is no vacancy, the government cannot continue with your services.
But it
then
is a
what happened
categorical
was-
statement. Firstly, it is a categorical statement that these appointments are ad hoc state appointees with the approval of the government in exigency of service. Meaning thereby they are not regular appointees.
According to what they have stated.
According to
but
their
according to the
statements.
Appointment orders are same with those of the petition.
But it is ad hoc.
In some case, it is not ad hoc, your lordship. It is temporary. In some cases. Page 143 and 144, your lordship. These are not ad hoc.
Yes, State Council. Though you have made the statement in the affidavit ad hoc, but page 143 and
44, your lordship.
144
Yes.
do not reflect so. Even in bold, 143. In bold letters, you have given this appointment comes under the purview of new defined contribution pension scheme.
Lordship, here in this case, ad hoc, both are ad hoc. So one is legally appointed ad hoc post. Appellant post is ad hoc, but without the sanction post, and illegally appointed by the incompetent office. So that's the only difference. Maybe I take it together, the post is same. Both are ad hoc. Subsequent appointed are ad hoc, and appellants, those who are illegally appointed, they are all ad hoc. But one is with the knowledge of with the sanction of the common, they are blamed without any sanction of the common, they were appointed. And those subsequent appointees are appointed just to meet the exigency. Anytime they can be terminated. So it cannot be a claim by the appellant that in the place the new appointed were appointed. So both are ad hoc appointment, but one is with sanction or with the approval of the common, appelling cases without the approval of the common. That's the only difference. And the department, I'm the employer. I know the employee, and how the employee can say that I was permanently appointed. It is the employer only, whether the appointment is given permanent or ad hoc. So under what circumstances the appellant can claim that you were appointed with the sanction of the or with the approval of the common. So that's the case. So I stand by the judgment rendered by the Honorable Single Judge. So that is the only core issue in this matter. Both I talk, one is with the approval of the government, one is illegal.
Yes, there is categorical statement in the affidavit that the agency of service they were appointed, and they were appointed not in the post vacated by you.
Your lordship,
So
that is what they are saying.
then in that manner, by maintaining a retention in this
yes.
manner, you can go on selling every appointment.
Your lordship, if that was the case, your lordship, but the way they have proceeded with I mean, the way they have made all these appointments. In 2012, we were saying that there are no posts. We were appointed without any post. Our pay was held up. Then immediately after that, your lordship, immediately after that, they started making all these appointments. More than 30, 40 of them, your lordship. All these appointments were made. After our appointments were, our pay and salary was held up. Now, your lordship, the issue, there's some deeper issue involved here. The then director, she, after retirement, she was to contest the elections in 2013, your lordship. So what happened was, prior to her appointment in 2012, all this, our appointments were, our pay and salary was held up. Immediately after that, she started making all these appointments, your lordship. Younger Lamla, she, the then director, Miss Dr. K. Younger Lamla, she contested the elections in 2013, your lordship, as a candidate, after her retirement. Now, it was during her tenure that all these shenanigans went on, your lordship. Now,
Okay, Mr. Pongjanar, we'll hear it and next week we'll dispose of this litigation.
your lordship.
Appeal.
Yes.
On the next one, Mr. Division. Let me go through the records in the meantime. Itu order to passport itu kali ada publication work kali we it over and go through the papers. Passing out the picture in the tomorrow evening we will say let me go through all these papers in the meantime. Okay. Item number. Okay, Chonjan Pongana for the appellants and Mr.
In terms of
Additional advocate general for the state respondents. List the appeal again on next, in the division minutes, before the division minutes in the next week. Try to dispose of.
For hearing, item number 23.
Read appeal.
Yes, sir. Needless question. The present rate appeal has been filed against the order dated 4/3/2022.
4/3?
4/3/2022. Judgment and order dated. Passing rate appeal number 176 of 2019. By this judgment and order dated 4/3/2022, 2 writ petitions were disposed of.
Page. Okay.
The judgment starts from page 85.
Hmm. 85, yes.
85. Before I take your lordship to the impugned judgment, the facts is like this. You seek the district level selection board.
District level selection board.
Yes, they have conducted a selection for appointment to the post of sweeper under the establishment of the ETC Pokobutu. The petitioner as well as a private respondent, they participated in the selection process. The private respondent, she was selected as select list number 1. The present appellant, she was selected as serial number 2. So, Rashid, the present lead petitioner, appellant, she filed this WBC number 176 of 2019 on the ground that the private respondent, she is not an indigenous inhabitant of Nagaland, so she is not entitled for appointment in terms of the standing policy framed by the state government. That was my condition in the writ petition. However, the learned single judge, by this immune judgment, dismissed my writ petition on the ground that since I've participated in the selection process, now I cannot turn around and challenge the state selection of the private respondent. That was the ground of dismissal of my writ petition. So my submission is received. Since my challenge in the writ petition was, since the private respondent was recommended for appointment and appointed, who is not eligible to be appointed in terms of the standing
So
policy.
who determines that about the indigenousness of a candidate? What is the criteria for determination of
Yes, Worship. Worship, I'll take your,
indigenousness of a candidate?
yes, Worship, I'll take your Worship to the policy framed by the state government. Worship, the policy is at page number 44.
Two?
Page 44.
44.
Yes, Worship. This is an office memorandum dated 7 December 2016. Worship, since the posting question falls under the grade 4 post within the district, Worship, the relevant provision clause will be clause number 4. Serial number 4. Worship. This is the grade 4 post.
Now, what document has to be submitted by a candidate?
Yes.
What document?
Your Worship, exactly. Worship. She submitted her indigenous inhabitant, the private respondent number 4, she submitted her indigenous inhabitant certificate in the selection process. That was accepted by the selection board and she was allowed to appear in the interview. In the writ petition, during the pendency of a writ petition, the state respondent, they conducted an inquiry. Thereafter,
that respondent who submitted a certificate.
Just Worship, during the pendency of my writ petition, her indigenous inhabitant certificate, that was cancelled by the state respondent.
That was
cancelled by the state respondent.
State respondent.
So she filed another writ petition challenging the cancellation. And her writ petition was allowed by the little single judge, directing the state authority to conduct a detailed inquiry.
Directing state authority to
conduct an inquiry.
Fresh.
Yeah, fresh inquiry. Inquiry was conducted after the immune judgment was passed. Now the inquiry report comes that she is not an indigenous inhabitant of Nagaland. Now the major stands still.
Okay, where is that?
Yes, Worship.
Where is that?
Worship, the state government were directed to file an affidavit enclosing the state government. They file an additional affidavit in the present meeting. Worship, called it the additional affidavit filed by the state. Worship, the
1 minute.
Page
1 minute.
Yes.
Yes, additional affidavit.
Page 12.
Page.
This is a letter issued by the state government to the Commissioner Nagaland.
Okay, this is attained, who represents respondent number 4?
Issued by respondent.
This is attained finality.
Yes, Lordship, a new cause of action arose by this fresh verification report. So Lordship, we have no other options. We'll have to file another writ petition because now we are after
No,
going
that
through
was
the
passed in 14/11/2022.
More than a year.
Today is
not more than a year.
Today is 15 November.
Lordship.
Huh?
The reason is that since her
You have been
identity.
served with, no, you have received this notice when? Report.
When was it?
Are you aware of this report?
Yeah,
Because you
letter of
preferred a
director
writ
served.
petition. You preferred a writ petition. Judgment was delivered at trace inquiry. You must have participated in the proceeding, right? So you are quite aware of the outcome, perhaps.
Lordship.
So you are sitting over it.
Yes, thereafter this fresh inquiry was conducted.
Huh.
And this report has been communicated to our party, Lordship. To that effect, we are admitted.
Then?
Lordship will have to file other writ petitions. That is in the process.
No, then otherwise the writable is to be allowed, isn't it?
Lordship, now the only issue
For that,
remains.
I have no say. I have no say as far as that writ appeal is concerned, because by that writ appeal, by that single writ.
This additional affidavit has also been filed on 9th May. Right? Even if we take that November, that report, you are not aware outcome. But by this affidavit, a copy has been served to you.
Lordship.
So you are aware that this is the situation.
Lordship.
Now the
Lordship,
issue.
the reasons why it is delaying, Lordship. May I just take a moment to explain it, Lordship?
She was appointed.
She was appointed, no.
She was appointed initially.
No, she was appointed, initially appointed.
Appointed?
But Lordship, she was appointed, but that was suspended by this Honorable Court. Lordship, by an order dated. By an order dated 16/8/2019, passed by the learned single judge.
16/8.
Lordship, the
In the
interim order.
writ petition.
In the writ petition.
Then after
During the-
your writ petition was dismissed. What was the order?
Lordship, her appointment was not challenged only by me. There was another writ petition challenging her appointment. In the other writ petition, by order dated 16/8/2019, her appointment was suspended. However, again, the other writ petition that was again withdrawn by the writ petition.
No interim order was passed in your case.
In my case, no interim order.
No. Then did you join?
No.
That even interim order, that was without hearing the private respondent.
After appointment.
Lordship.
There was appointment order.
She was an appointment order.
Appointment.
Where is that? Where-
And
that was
she has
suspended.
joined, even she has joined her office.
No, where is the appointment order?
Lordship, may come to page number 42 in the memo of appeal.
And where is the advertisement?
Lordship, the advertisement is at page number. Page number 32, Lordship. This is a common advertisement.
Which district?
Lordship, it comes under serial number 14, Pokoputu.
Grade 4.
Grade 4, Lordship.
1.
Lordship,
So did you join?
Yes, Lordship.
Work for 1 day or
That was, appointment order was issued on 1st August 2019.
yes, I have
Then
seen.
lordship, we joined on 8/3/2022. Joint report.
Who is the appointment order, Mr. Lima Apong?
Lordship, the appointment notice at page number 42. This is our appointment of Lordship. And Lordship may kindly come to page number 48. This is an order passed in WBC number 125 of 2019. In this rate petition also, her appointment was under challenge. Lordship. By order dated 16/8/2019.
The question why I'm asking is that appointment order has been issued. If she has joined, if the lady has joined, even for 1 day, that selection process has come to an end. Right? Then subsequently by an order of the court, if her appointment stands cancelled, that selection process is over and out. For the post, the relief you are seeking could be a fresh selection process only.
But Lordship, in the present case, Lordship, I don't think there's any record of her tuning her post in pursuance to this order dated 1st August 2019.
You have challenged this order
I've challenged this
in the appointment, in the writ
in my
petition.
petition.
Even after that, she has joined for 1 single day. Thereafter, her appointment is cancelled. Then this, after cancellation, this you cannot start from the stage of the advertisement. It has to be a fresh selection process. Yes, that is the, I think, find out that law, it is exhausted.
And lordship, despite of all these cancellations of my inhabitant certificate, indigenous certificate, my appointment order is not been terminated so far. Not been terminated, no official terminations.
Lordship, in the affidavit in opposition filed by the present private respondent in the writ petition. Lordship, there is no record showing about her joining the post.
Lordship, I have documents which additional deputy commissioner, the head of department, who has received my joining report. I have.
Then you file a short affidavit to that effect. After appointment, you have joined, or you have already made statement anywhere.
No. I have not filed any objections to this.
Did you receive any money, salary?
No, lordship. No.
Joined work for 1 single day at least?
Yes, we have joined. Thereafter, again, that
Yes,
inquiry
Mr.
has been.
State Council. Because relief
Yes, sir.
the petitioner or appellant is seeking is that her appointment should be cancelled or is to be cancelled. Now, question is, if she has joined pursuant to the appointment, that selection process has come to an end. Right? If her appointment is cancelled and that post becomes vacant, then there has to be a fresh selection process in that case. If she has not joined, not even work for a single day, perhaps case of the petitioner may that her position is your waiting list.
I'm in the waiting list.
This also now becoming valid.
That issue will receive the validity of the select list.
Law,
Validity of the select list. It happens during the validity of the petition. the validity of the select list,
Huh.
it occurs during the pendency of the present proceedings.
That time, even that she was still in the service. But the respondent was still in service.
No, Lordship. Her appointment order has been already suspended by this local court. In there's no record showing that she has joined the service.
Suspended. Find out from whether she worked, joined and after joined, because stay order was passed on 16/8.
16/8.
Appointment order was on 1/8.
1/8.
So there was a gap of 15 days in between.
15 days.
Lordship, see, after this, another writ petition was filed.
That
And
was
by that-
said, withdrawn.
By another writ petitions that stay order was.
We are concerned with these two writ petitions.
Yes, Lordship. Then thereafter, since now that on withdrawal of that writ petition, we have joined on 8/3/2022, and that was received by the additional deputy.
Mr. Shivapam,
Yes, my lord.
you get an instruction whether this lady had joined pursuant to her appointment or worked for 1 or 2 days in the office.
Lordship, next week.
Then that selection process is gone.
Yes.
So if we set aside the appointment of the private respondent, we can only observe that a fresh selection process be initiated in the vacancy arising out of.
If she has joined.
Huh?
If the private respondent has joined the service.
Yes.
Lordship, that is on next Wednesday.
Wednesday?
October.
Okay, heard Mr.
Lima Wakang.
Lima Wapang, Learned Counsel for the appellant, writ appellant, Mr. Thiba Phone, Learned State Counsel. And Mr. Very difficult to pronounce.
Yes.
Kakrian Gule,
Lordship.
Learned Counsel for the private respondent number 4. Full stop. Mr. Thiba Phone, Learned State Counsel, shall obtain instruction whether pursuant to the appointment order dated 1/8/2019.
2019.
The respondent number 4
Yes, Lordship.
has joined in the post of
Sweeper.
sweeper
Under the
in the establishment of the additional deputy commissioner office, Pugo Boto, till the order of appointment was suspended by an order dated 16/8/2019 passed in a writ petition, WBC number 125/2019 and stroke or any period thereafter. As Mr. Trivapam has fought for a week's time to obtain the instruction, raise the case in the next week, read the appeal in the next week. Yes, anything else? Yes.
Item 24.
Hmm.
It's a lengthy matter, my lord. We may not be able to finish today.
Some other day then.
Coming Wednesday, can we try again?
Huh? Next to next, I have fixed already for
Yes,
for
I heard
for
about it, yes.
disposal with the intention that I'll dispose of.
The next
Okay, next to
available-
next week.
Very well, madam.
Okay. A Jimoni Learned Counsel for the appellant. And
I intend for respondent number 9, Your Lordship.
I Im Chen, Learned Counsel for the respondent number 9 and Mr. Thiba Phom. He appeared in item 24.
Additional AG.
V. Supre, additional agent.
P. Chukre, and traditional AG for the state respondent present. Okay, we'll raise the case in the before the division bench in the week commencing from 28th November.
28.
It will be before the division bench, it will be 30.
I'll not be here on 30th.
Okay. 4th of December. Week commencing, it will be 6th.
We commencing on the 6th.
Division bench may sit on different dates because festival will be there. Few more judges may be available. in the week commencing from 4th December 2023. Yes, anything else?
My lord, in regard to item number 25, my lord, here currently, I need to place one order, and basing on that order, the matter may be closed, my lord.
Okay.
Yes, only one letter.
Next week?
No,
Or
my
this
lord.
can be closed?
Yes, yes.
Okay, let us see. Anyway. We will continue to the.
My lord, your lordship may kindly see the next page, second page. This is the instruction received from the department. Yes, as per this letter, the petitioner is entitled, my lord.
Yes. It can be closed.
Anyway. What was the prayer in the writ petition?
Lordship, for grant of back wages from the period of dismissal, that is from 04/07/2011 to 15/8/2019.
The petitioner
Lordship, appellant.
had MS.
Ubang Nanlalongcha. Your Lordship, my name is not in the cost list.
MS.
Ubang Nanlalongcha.
Learned counsel for the learned counsel appearing for the writ appellant, and Mr. Thiva from learned state counsel for the respondents. Full stop. The appellant as the writ petitioner had preferred the writ petition, had preferred a writ petition, WBC number 169/2019, seeking indirectly a direction for payment of regular skill pay and consequential benefits retrospectively, WEF 47/2011, right?
Yes.
07/2011.
Agreed by the judgment and order dated 14/2/2023, passed in the writ petition WBC number 169/2019, this intra-court appeal has been preferred by the said writ petition as the writ appellant. Full stop. In the writ appeal, a prayer has been made seeking a direction to pay regular pay scale salary and all other allowances, along with all consequential benefits, WEF 47/2011. Full stop. Mr. Have you gone through? Mr. Thiva from United State Council has placed a copy of a communication bearing number so and so dated 2/6/2023 of the additional secretary to the Government of Nagaland, Finance Department, address to the Home Commissioner, Nagaland, Kohima. Before this court. Post of. By placing the same, Mr. Chivafam has submitted that since the services of the petitioner, appellant petitioner, has been reinstated with retrospective effect, the state government has taken a decision that the appellant petitioner is entitled to salary for a relevant period on and from 4/7/2011.
Yes, sir.
First of, by the, so a perusal of the communication being dated so and so goes to mentions by the state in the state communication. It is mentioned that since the services of the appellant petitioner has been reinstated with retrospective effect, the appellant petitioner will be entitled to salary, is entitled to salary of the relevant period from 4/7/2011. And the Home Commissioner Nagaland has been directed thereby to take necessary action on the matter accordingly. MS so Council, preparing for the appellant petitioner, has submitted that since the government has taken a decision in the manner mentioned in the communication dated so and so, the grievance of the petitioner appears to have been effectively redressed. So she has thus submitted that this appeal can be disposed of reserving, however, liberty to the petitioner to approach again in the event of any subsequent action in connection with the issue raised in the petition stroke appeal. I am reserving the liberty to you. If you have any grievance, you can come. Right? In view of the above submission made by MS Swensel Land Council appearing for the appellant, this petition appeal is disposed of as infectious, is closed, reserving the liberty to the appellant, as sought for. You have received a copy?
Oh.